Hey there. So yesterday we got the result in an important case of ours. It was our charter challenge to British Columbia's vaccine passports. Remember them? Well, BC did not have a workable system for medical exemptions for people who could not be vaccinated, and we challenged the regime. We lost at lower court, and today we got the result in the appeal. And I'm going to warn you, it is mostly bad news, but there are a few silver linings. Let's get into it. If you're new here, welcome. My name is Christine, and I'm the litigation director with the Canadian Constitution Foundation, a legal charity that fights for fundamental freedoms in Canada. I upload regular videos about our ongoing legal cases and about other interesting developments in constitutional law in Canada. So if that sounds like something you'd be interested in, please hit like and subscribe below. It really helps my videos out a lot. Also, please remember, nothing in my videos is ever legal advice. If you have your own legal question or problem, please consult your own lawyer. So we got the decision in our BC vaccine litigation, and I'm pretty sad about it. You might remember this case. I've talked about it on the channel a few times. There's a bunch of videos about it. And we argued this appeal in October of 2023. So, I mean, it took a really long time to get this decision. So I'll forgive you if you've forgotten about it because it took so long. So this was the appeal. The case is called Cassian and British Columbia. And the case was a charter challenge to the BC vaccine passport scheme for lacking workable medical exemptions for people who couldn't get vaccinated for medical reasons. They had this really convoluted regime that kept changing. For a while, it didn't have any exemptions at all. And then for another period of time, you had to apply on an activity by activity basis. So you had to send in a separate application to go to a friend's house, to go to the movies, to a restaurant, basically forcing people with disabilities to require the government's permission every time they left their house. Then for another period of time, they stopped taking applications at all. For another period of time, they had this form with a list of conditions, like a checklist of conditions for which you could apply for an exemption, but rare conditions weren't listed. Just the most common adverse side effects to vaccination or common problems were listed, but nothing rare. And it also seemed like doctors at the time were really afraid to write in anything other than the conditions on that closed list of government-approved reasons for seeking an exemption. So we challenged this terrible and unfair system. We said it was discriminatory against people with disabilities under Section 15 of the Charter, and that it violated the right to life, liberty, and security of person under Section 7 of the Charter. The case involved us, the Canadian Constitution Foundation, as a public interest litigant, and three women, a woman named Sharon, a woman named Veronica, and a teenage girl named Erica. So Sharon had developed a rare reaction to the first dose of the COVID-19 vaccine, so she wasn't on that checklist of common conditions. Her condition was called brachial neuritis, and Erica, the teenage girl, she developed a more common reaction that is more common among pediatric patients. She developed an adverse reaction to the first dose of the COVID vaccine, a type of heart inflammation called pericarditis. Now, the third woman, Veronica, she's a medically complex person with a long history of adverse outcomes in response to surgeries and drugs. And because of her very complicated medical history, she decided to decline vaccination. Now, the bad news is that the appeal we brought was unsuccessful, and I am pretty devastated about it. I'm more devastated on behalf of these women. This was really, really important to them. Now, let's get into what the decision says. First, a few good things. I mean, I do think that the court this time fairly described the very difficult situation that Sharon, Veronica, and Erica were in, and they described that situation with compassion. This is something that was lacking in the lower court decision and was lacking during the broader discourse at the time during the pandemic about medical exemptions. So I am grateful that there now seems to be a broader understanding about the needs of medically complex people who are living with disabilities, and they're being considered with more compassion than they were during the height of the pandemic. I remember during the height of the pandemic, people said, I don't care that these people can't get vaccinated. They should do it anyway. Or I don't care that these people can't be vaccinated. I think that they just should not be allowed to leave their house. Like, that was crazy. And it seems like people aren't saying that anymore. So that is good. So here's how the court described the different women. They explained what happened to Sharon. She was a school secretary who, after getting her first dose of the Pfizer vaccine, woke up in the middle of the night with a severe pain in her right shoulder. She went to the emergency room, and they got her in a month later to see an orthopedic specialist. She was diagnosed with this condition, brachial neuritis, and the doctor told Sharon, this orthopedic doctor, told Sharon at the time that it was likely a rare reaction to her COVID-19 vaccine. But she didn't have any documentation of that diagnosis. And the court noted that this consultation with the specialist does not mention the vaccination or suggest any link to the condition. And look, that's true. And we all kind of can assume why now. We know that a lot of physicians were really loath to talk about adverse reactions or give formal opinions about it, even though they might tell her verbally that that is what they think caused it. That wasn't in the decision, though. Sharon then went on, after seeing this orthopedic specialist, to see a neurologist who agreed with that diagnosis of brachial neuritis, and noted as well that this time in the report that Sharon had just received the COVID vaccine. But that neurologist report didn't explicitly link the two. The court also noted that her family doctor gave her a note for a medical exemption for work, to exempt her from vaccination at work and her job as a school secretary. But the court said that that letter to her employer was not like an official letter. It wasn't sent into public health. So just think about all of the red tape and bureaucracy here. Like, oh my gosh. She also went to see another specialist, a physiatrist, which is like a rehab doctor. And the rehab doctor initially was open to writing Sharon an exemption to public health because she already had the one for work, but that wasn't good enough. But then ultimately the physiatrist, the rehab doctor, decided not to. And again, this is my opinion being added here. We all like know what was happening. Doctors were under tremendous pressure, unofficial pressure, not to write these letters for these rare conditions. And part of the reason was that they were under this pressure was the government vaccine passport system was now in place, and they had this closed list of approved reasons for getting an exemption, and Sharon's condition wasn't on it. That's kind of my color added there. But the court decision actually described all of these things that happened to Sharon. So I think that that's fair. They really characterized it in a compassionate way, I think. That was Sharon's situation. The next woman that we were working with was Veronica. And again, I think in Veronica's case, the Court of Appeal did a fair job in characterizing what was happening. She was born with a condition called spina bifida and hydrocephalus, which are medically difficult conditions. They limit her ability to walk. She has had over 15 surgeries in her life, many with poor outcomes. This is how the court described it. She has chronic health problems and has had very severe reactions to some medications and to anesthesia. And as a result of those difficult experiences, she reached the conclusion that it would be unsafe for her to receive a COVID-19 vaccination. That's what the court wrote. The court also wrote that Veronica isn't suggesting that she received any medical opinion to the effect that vaccination against COVID was contraindicated. She doesn't provide any evidence of a request for documentation from a doctor to support an exemption. Rather, she simply relays her impression that doctors were unwilling to seriously consider giving her an exemption. And that's what the court wrote. And, to me, this is a similar problem to what Sharon had, although slightly different, because Sharon had had more doctors willing to link, at least unofficially, an adverse reaction to her inability to get a second dose. In Veronica's case, I think we all know what was happening. The court didn't say this, but we know that many doctors were afraid to consider giving her an exemption. I think her conclusion, this is my opinion, that it wasn't worth trying to get an opinion from a doctor to do this. I think that I understand why she reached that conclusion. The big problem for Veronica, though, was as I said, because of her medical condition, she had trouble walking. She has a lot of mobility restrictions, and she uses swim therapy at her local pool as a way of addressing her pain and her symptoms. And before the pandemic started, she used to swim 3 hours a day, which is a lot. After December of 2021, she was not able to use the community pool because she was unvaccinated and she did not have an exemption. And the inability to engage in swim therapy had a serious detrimental effect on her. Her disabilities mean that she has limited opportunities to engage in social activities, and her inability to attend gatherings and go to restaurants, that led to increased social exclusion, which she's already vulnerable to as a person living with a disability. And that was all how the court described it. And I think that that's a fair characterization by the court. Now, the last person that we were working with was this teenage girl named Erica. Erica is a competitive swimmer and was a part-time swim coach, and she got vaccinated in her first dose in May of 2021. And 4 days after that, she experienced this really sharp stabbing pain in her chest, and she was diagnosed with pericarditis, a type of heart inflammation. And her family doctor gave an opinion that the pericarditis was likely a reaction to her first dose of the vaccine. And after consultation with a disease expert, the doctor received a strong and clear recommendation that Erica not get a second dose. Now, Erica's condition qualified for an exemption under the public health guidelines. Remember, there was that list that I said the government had created. Pericarditis was on that list. She could have asked for an exemption, but the initial version of the form that was in effect for this period of time said that a person had to apply for a separate exemption each time they wanted to do something. So it suggested and was pretty clear, actually, that a blanket exemption wouldn't be granted. And these are the words of the court. They said the form suggested that a blanket exemption would not be granted. That's what the court said. And then the court described us, the Canadian Constitution Foundation, and I do think that they described us fairly, for a change. Sometimes we're described very unfairly. When we did this litigation, when we brought this case, a lot of people said, like, we are an anti-vax group because of this case. Look, I am not anti-vax. I think that the idea of calling someone anti-vax is a way of trying to discredit them. It's an ad hominem attack that people use against those they disagree with. Like, we don't characterize ourselves as anti-vax. Being opposed to vaccine mandates does not make us anti-vax. Like, you can go and get vaccinated. I'm not against vaccinations. I'm against the government giving you sanctions for declining vaccination for your own reason. And the court didn't call us anti-vax, and I really appreciate that. They acknowledged that we at the CCF, we said that COVID is a serious illness, but that individuals should not be subject to government pressure to obtain vaccinations. People should be left to make their own decisions without the specter of state sanction. And I think that that is a very fair characterization of what I think. I also think that the BC Court of Appeal did understand our arguments about the problems with the vaccine passport regime. It was complicated. It was in constant flux. It changed multiple times. The rules would fluctuate between how rigid they were. At first there were no exemptions, and there were limited exemptions. Then they stopped taking exemption requests at all. Then they had a medical deferral form that could only be completed by a doctor using that checklist of acceptable reasons with no write-in category. The court understood all of this, and I think that they understood it at the Court of Appeal better than the lower court did. They understood that there was this checklist. They understood there were no blanket exemptions for a period, and they described all of these problems, and I think that that's good. Now let's get to the bad stuff. The court sided against Sharon, the woman with brachial neuritis, and Veronica, the woman who was medically complex, because the court found that even though the forms said one thing, the public health forms said one thing, the court thought it was reasonable that the BC public health officer thought they said it's something entirely different. So the BC public health officer interpreted those forms as not having a closed list of conditions available for exemption. And the court found that that interpretation is reasonable, even though it contradicted the text of the orders. The public health officer said, even though it had this checklist of what the approved conditions were, they actually were giving people exemptions who had other conditions. Now, I don't know how anyone was supposed to know that the public health office was secretly granting exemptions in contravention of their own form, but apparently that's how they were interpreting the rule, and our patients were somehow supposed to know about this secret interpretation. And unfortunately, the Court of Appeal here granted deference to the BC public health officer's interpretation of that regime. This is crazy to me. I completely disagree with this analysis. The patients that we worked with in this case, Veronica and Sharon, they read these orders and they concluded completely reasonably that they were not eligible for an exemption. They looked at this form with the checklist of conditions that you could apply for based on, and their conditions weren't on that list. And I do not think that the public health officer's interpretation is a reasonable one, and it should not get deference. It also undermines the rule of law that a public health order can say one thing, like create this list of acceptable reasons for an exemption with no option for other reasons, but then they can act like the order says something entirely different. For Sharon and Veronica to get to court, be told that the government granted exemptions even for unlisted conditions without making this public and doing it in secret, and then getting the case dismissed for not asking, like, that is a huge breach of the rule of law, in my opinion. And I think that it excuses government opacity and allows for ex post facto, like after the fact, justification for the government's conduct. So on that basis, the claims of Sharon and Veronica were dismissed as premature. There was a little bit of good news for Erica. So remember, Erica was subject to these activity by activity exemption requests. So she was supposed to apply every time she wanted to do anything. And the court held that it was arguable that for that period of time, there was no remedy for Erica to obtain a blanket exemption. Between November 12th, 2021 and December 23rd, 2021, so for about a month and a half, the public health exemption guidelines specified that the exemptions were only available on an activity-by-activity basis. In other words, there were no blanket exemptions. And then the order preambles contained that language until February of 2022. So from the beginning of November to February. So quite a long period of time that she was expected to send in these requests every time she wanted to leave her house. And for that period of time, the court in British Columbia held that the interpretation of the orders to permit blanket exemptions in violation of what the language actually said. They said that that interpretation is unreasonable. So Erica only learned that public health was actually granting blanket exemptions, even though the text of the orders didn't allow for that at all. She only learned about this because she sued. So she never knew that they had this secret other interpretation. And I don't know how she would be expected to know that. The public health office never stated in the guidance or on their website or in their public comments that they were giving blanket exemptions in contravention of the text of their own orders. And the BC Court of Appeal said that that was unreasonable, and that the rationale for denying blanket exemptions in the actual guidance of the orders, that rationale was never apparent. And the court said that this supports the view that the orders were more restrictive than necessary. That's good. The court said that the conduct of the government here was unreasonable. They wrote in paragraph 80 that during that period, on the face of it, there would appear to be some force in the argument that a regime that unnecessarily restricted exemptions to individual activities or a series of activities served to further the disadvantage of persons suffering from medical conditions contraindicating vaccination. So that language, furthering disadvantage of people with a protected condition, in this case disability, that's the language of section 15 of the charter, the right to be free from discrimination or having your disadvantage furthered by government action. Like, that to me sounds like a section 15 claim would have been successful, but the court declined to do a charter analysis. And they said that they weren't going to do a charter analysis to find if there had been a violation of Erica's rights, because they said all they could do was issue a declaration since the orders were no longer in effect, and a declaration would have no practical consequence. Look, I'm happy that the court found that the lack of blanket exemptions for Erica was unreasonable, but I am really disappointed that they declined to conduct a charter analysis. Like, what was the point of even hearing the case? Which they already knew this was moot. They had a whole separate decision that they were going to hear this case even though it was moot. Like, if they decided to hear it, why hear it if you weren't going to actually do the analysis? In my view, if they had done this charter analysis, there would have been a finding that Erica's charter protected right to equality, to be free from discrimination, was violated. And I think there's a good chance that her right to life, liberty, and security, there would have been a finding of violation there as well. You know, as a young woman who was experiencing a new and painful and frightening disability, after already spending her teen years in pandemic isolation, she would have really benefited from a declaration that what the government had done to her was wrong. Now, the silver lining in this case is that the court held that there is no public interest in vaccinating people who are medically contraindicated against vaccination. I mean, that's good. That's something that was missing during the public discourse during the pandemic period. So I think that there are a few things in here, like this finding about what happened to Erica, that will give future governments pause and might restrain them from doing something like this in the future. So unfortunately, this is not the good news I had been hoping to give you today, but there were a few little glimmers of hope. If you want to read the decision, I will put a link to it below. And look, even though this wasn't the outcome that I wanted, I'm really proud of the work that we did in this case, and I'm really proud that we went out there and we stood up for these women, even if it got me called all kinds of names at the time. And to everyone who supported this case, I'm proud of you as well. And thank you so much for supporting us and for supporting Sharon, Veronica, and Erica. Okay, that's all for this update. Thanks for watching, and let's keep fighting for freedom in Canada.